period.
All right, thank you so much for staying with us. We're looking at the options for aggrieved parties in the Kogi supplementary election. Now, lawyers of the Kogi State Governor, Captain Idris Wada, are preparing to appeal the ruling of the Federal High Court, Abuja, which declined jurisdiction on the suit filed on the decision of the Independent National Electoral Commission to organize the December 5, 2015 supplementary election.
The deputy governorship candidate, James Falake, has also vowed to challenge it in court. We don't know if he's still the deputy governor because he's asking to be declared as governor.
Yes, indeed. Now, Justice Gabriel Kolawole, who delivered the judgment, said that going by Section 285, subsection 1 of the Constitution and Section 87 to 10 of the Electoral Act, the Federal High Court lacked the jurisdiction to grant relief sought by the plaintiffs and therefore directed them to the election tribunal.
Well, the supplementary election has come and gone. Yahaya Bello, the first runner-up in the APC primaries, has now been declared winner. He polled 6,885 votes in the supplementary election on Saturday and, of course, declared winner.
Well, we'll be taking up issues arising from the court ruling, the implications of the supplementary election, the options of going to the appeal court or the tribunal.
We have joining us now Chief Dan Nwanyanwu. He is a former chairman, Board of Trustees, Labour Party, and former national chairman of the Labour Party. He is also a lawyer, so we'll be looking at some legal dimensions to this particular issue. Welcome, Chief Nwanyanwu.
Thank you very much. Good morning, Nigeria.
You're welcome. You look at the Kogi State supplementary election and the arguments thereof concerning whether or not the election should hold. That was before the election, and we had the appeal court rule that the Federal High Court rule that it was not within its jurisdiction to rule on the case. What do you make of this ruling and the implication for the elections?
Yeah, the last time I was here, I recall I made the argument that the APC was entitled to replace the dead candidate in that election, and that the election should start de novo. Well, INEC did something different after consulting their consortium of senior advocates in their own wisdom. I still hold the view that Alhaji Yahaya Bello is not entitled to benefit from the 241,000 votes meant for late Abubakar Audu. And he cannot, and he shouldn't have been declared the winner, having scored less than 5% of the total votes cast in that election. I want to take this from three perspectives. Let's look at the justice of the matter. Let us also look at the equity involved, and then the doctrine of necessity. If you look at the justice of the matter, in my own opinion, I think they should have gone back to have a fresh election. If you ask if it will be equitable, you may look at Faleke, that he has some claim to that vote, to the votes of 241, even though he was not the main candidate, because they are running on the joint ticket. Now, if you come to the doctrine of necessity, I think that was where INEC hinged his position. And that will lead me to a question, whether justice is dependent on law or whether law is dependent on justice. It is my considered view that the exercise conducted by INEC will not stand the test of time if we pursue it legally. Justice Kolawole, very serious judge, from his position, they must have gone to talk about election. When I came here the last time, I talked about interpretation. So if they have gone to talk about, we have done election, the man has died, they have brought somebody, they want to conduct an election, they cannot do this, Justice Kolawole will say, no, I don't have jurisdiction. But if they have gone under case stated as provided in the Constitution, whereby you can go to the Federal High Court to ask interpretation of certain provisions of the law, even when you put it in the Federal High Court, you may also put an application to take it to the Court of Appeal. As they are hiring it, you put another application, it gets to the Supreme Court within a short period of time for them to determine that matter.
When you say short period of time, how long does it take to determine such matters if INEC or the aggrieved parties have taken that
you see, under case stated, it moves very fast because the learned justices are aware that there is something very important that will determine certain things it's flowing from. But the problem we have is that, we're always in a hurry. I have always said that. We're always in a hurry. INEC was in a hurry. There was an issue to be decided. The fact that you have consortium of senior advocates doesn't make it right. You may have 50 senior advocates advising you on the matter. It may not be correct. We have had cases where you have those senior advocates, a young lawyer will make it in the court with due respect. So when you say consortium of senior advocates, you give impression as if it is sacrosanct or it is cast of stone. There is no way under section 141 that Yahaya Bello will be entitled to those 140-something thousand votes. And Justice Kolawole was right. So going to that court and getting this position, I dare say that it may get to that same point at the Supreme Court, because from the provisions cited by Justice Kolawole, they came to him to decide issues of election, which is within the purview of the tribunal. But if you have gone to the court
for interpretation
to interpret,
I think one of the issues, because there were 3 or 4 consolidated cases.
Yes.
One of them actually was about. Some of them were actually about interpretation. Some of the issues raised for determination by the parties to the court was interpret for us whether or not this election can continue or whether a fresh election should be called for in the circumstance of what we're finding
that is the problem. Whether this election can continue.
But can you really divorce issue of election?
Yes.
Whether the case stated you are talking, because even the case stated is still about election. What's the basis of the case stated?
You see, when you are talking about whether the election can go on, there is a provision in the Electoral Act that you cannot stop the election. But if you are going to interpret certain provisions, whether by virtue of this and that, it doesn't mean this. If this is the position, should this happen, INEC will be joined in the case. So it's not a question of running away from the issue. It's not running away from the issue. And I think the way they approach it may have affected or may affect the finality of the matter. Because by the time you get to that point, you will find out that we don't have jurisdiction up to the Supreme Court. And let me also make a point. You raised something now that Faleke withdrew. He said he was not part of the election. That withdrawal amounted to nothing. It has no meaning. By virtue of the Section 33, which hinged on Section 31 of the Electoral Act.
That's the political parties have to be the ones.
Whether he announced he withdrew or not, amounted to nothing. He is by records today, he is the elected deputy governor of Kogi State.
Can you force an unwilling servant on anybody when the man who is nominated as a deputy governor says he's no longer a deputy governor, rightly or wrongly?
Yes.
I know the law says it's only the political party that can write to INEC and it has any legal effect. Even in this circumstance, does Yahaya Bello has a deputy governorship candidate?
Even at that, even if the political party had written to INEC at that point withdrawing Faleke, it would have also amounted to nothing. The same argument I made on replacement of candidates when I cited, you recall, the case of Labour Party and INEC on Adamawa issue. It is the same argument because nomination has since closed. You cannot open it. The only window available is if the man is dead. So if a candidate sees that he doesn't want to, if the intention was to puncture a candidate's election, the only option he has is to die.
Which obviously he doesn't have. But let's look at...
I'm sorry. Yes. The only option he has is to die. Our law is very strong and strict on the matter. He cannot withdraw. He cannot be withdrawn. So both his exercise of withdrawal amounts to nothing. I am talking what the law says. I am not fabricating it.
But did the law also consider the possibility that a candidate might not want to continue again?
He had the opportunity not to continue before the close of nomination.
So after
there is a window for withdrawal.
Yes.
Where you withdraw, another man moves in. But once that window has been shut, you can never withdraw or be withdrawn unless you decide to die.
Now let's look at this issue because it's getting even more interesting after the elections. The window for nomination had closed.
Yes.
Yet APC went ahead, picked a candidate that ran the primaries to stand to replace APC's candidate.
That point, sorry, let me not cut you so I don't forget this point. The fact that Yahya Bello was the second runner-up in the primaries, the first runner-up, doesn't give him the cloth that he has been part of the process. His own process ended with the emergence of Abubakar Audu, who now continued the second leg of the process by gathering votes. And what section 141 of the Electoral Act talks about is you must have to be part and parcel of all the processes up to the vote. So where you miss one step by the provisions of the law, you cannot benefit. And I hold this view very strongly.
INEC was going on the basis of assumption that it's a political party that is at stake here legally based on Supreme Court precedent as well. It's a political party. So based on that assumption, are you saying that assumption, which is why they allowed the APC to substitute and bring in Yahya Bello, that assumption is not based on the law?
You see, I also appealed the last time when I referred to the authority cited by the Attorney General that it is the political party that conducts election or participates in the election, not the candidate. And it refers to section 292, am I correct? Let me tell you. You see the Amechi's case, as I told you before, that case, if you take it back to the Supreme Court today, the same justices, their position will be different by virtue of section 141 of the Electoral Act.
Over 80% of them unfortunately have retired.
No, I'm just making an argument for argument's sake. Because that was the mischief. Amechi did not campaign. Amechi did not print poster. His Excellency Governor Amechi, as he then was, did not campaign, ask for votes, but he was just railroad from Ghana to Nigeria into government house. So that was the mischief that the National Assembly corrected, that made Amechi's case no longer tenable in our laws today. So that's why I said, if you recall the same justices of the Supreme Court and put Amechi's case before them with section 141, their position will be different. So he cannot, as a matter of fact, benefit from it. INEC has announced winner. Let them go to the tribunal. That is the option available to them now. But I'm not too sure if the tribunal will address this particular matter.
So what will be the next step? Because
you see, at times we have a system of laws that is very slow, but at times cases are dismissed based on technical grounds, even though the higher courts have always made the position that, look, here every case on its own merit. If you ask me, I would plead that this case be determined based on merit. If you determine this case based on merit, it will guide us. I know before the next election, the National Assembly will also take care of this aspect when they'll be reviewing the Electoral Act, because it was not anticipated. But I have also held the view, which I told you the last time, that if you look at the section 181 and look at section 36, which has to do with death of a candidate. One is after being proclaimed a winner, the other one is before poll. I said that what I read from the intention of the legislature, what I read from the minds of the lawmakers, is that at any stage of the election and death occurs, INEC carry a while, allow the party to replace and start de novo. That is the intention of the legislator. One is after proclamation, you have been declared a winner, you are not in any position to be sworn in, to take your oath of office and oath of allegiance. The man that won with you will be sworn in. The second aspect is before polls, you stop. So the intention of the legislator in this, in my view, is that anytime you have the death of a candidate, INEC should stop, allow the party to replace, and start de novo.
All right.
That is my view.
Now let's look at other options now. The case, the court declined jurisdiction on Friday.
Yes.
Says there's option of appeal to some of the parties who say they want to go and appeal.
Up to Supreme Court.
There's also the option of going to the tribunal, filing an election case, election petition at the tribunal. Do you still see a risk of technicalities playing out here? Because when the issues at the regular court in the pre-election matter is almost similar to the one before the tribunal.
Yeah,
there's a technical issue of abuse of court process which will also knock down the case, and at the end of it we don't find it being decided on its merits.
What I see happening in the Court of Appeal, what I see happening in the tribunal is that the tribunal will try as much as possible to avoid it, because they are to determine who won the election. Although in the first powers of the tribunal as to find out whether the person that won the election is actually supposed to win is supposed to contest the election. Yahaya Bello is entitled to contest the election, but whether he was entitled to benefit
from the votes
is a different matter. That's why I said Attorney General would have done us a favor by taking the matter up, or even going on that case stated for the court to interpret what has just happened. Section 141 that is sitting there is a very serious impediment for anybody to benefit from what he did not sow. He cannot read from it. That is the intent of section 141, and that section is very, very strong. So with the result that has been declared, I don't know. They will go to tribunal. Of course, the PDP has been arguing that they should be declared for legacy. The PDP
they have several people claiming interest in this.
No, PDP cannot be declared. They know it. I think they are just adding spice to the whole thing, as I said before. They can't be declared. There's no basis for declaring them. They've not scored the highest number of votes. They've not gotten the spread, and that's why the issue of de novo.
But if it is found out that the Yahaya Bello, who scored 6,885,
less than 5%,
yes, wasn't a legally and lawfully recognized candidate, does that not give advantage to the PDP, who scored the majority of votes cast in the main election?
I don't know why he would not be. I don't want to speculate. Anybody could have been. APC has the right to put anybody, including Abubakar Audu's son, to be a replacement for late Abubakar Audu. So you cannot go and challenge his participation. The issue at stake is, did he indeed score the highest number of votes?
As a candidate.
As a candidate. Okay. So that is the question. That
is what the PDP seems to be hanging upon. That's a lifeline as far as this particular case is concerned.
Well, because if that argument is strong, if they canvass it, it will not give them victory.
Anyway,
it will return them to the starting line.
All right, then.
Yes.
Let's move away from Kogi election now and talk about another issue that's been dominating headlines for the past 1 week. That is the detention of former chairman of Dar Communications PLC, High Chief Raymond Alehodopasi, by the EFCC for over a week now. What is your evaluation of what's been going on?
Well, you see, the family issued a statement of the true state of affairs. You see, there is one thing in Nigeria, on the issue of fight against corruption by this administration, I am on the same page with President Muhammad Buhari. We must fight those who have stolen our money. But in fighting corruption, we should not attempt to damage the integrity of persons who maybe did not hold public office, who had no access to public funds, as in this case. Because my reaction to it, after I have seen the government position and the reaction of the subject, I say, well, let us ask ourselves, is the function or the job of the National Security Advisor of a country restricted to arms procurement? And even the way now we are talking about security issues, I'm very uncomfortable with it. His job doesn't start and end with procurement of arms. There are certain things they do in that office that will stabilize the polity that you don't even know. So when we start opening up that office for everybody to see, we will now be talking about the security votes that we have all over the country that we cannot inquire about. And I gave an example. And I will repeat my example to you. You are owing me money. I have executed or have rendered services. You said, okay, I have agreed, we have agreed on this, you have done it. You say, well, wait, he will pay you. So person will pay you, the person pays me. I issued my receipts of having been paid. If there's a balance, I'll state so. What is my problem with the payer? With the payer, how he got the money. My interest is to pay me for services rendered. Legitimate service rendered. You see, when I made this comment before, some friends called me. I called them for a conference. I say, I am not into frivolities. I know previous administrations in Nigeria, in the office of the National Security Advisor, have done things beyond procurement of arms, even into the political parties, even to stabilize the polity. These are things that are not known. Even this government will also use the same office to do certain things to stabilize the polity.
Now, Chief, just before we go, let's look at some of the procedures that EFCC has followed, to arrest, or rather to call some of those around the $2.1 billion arm. Do you think that the EFCC does have, the magistrate court really does have jurisdiction?
I'm coming to that point. In civilized crimes, you have to finish your investigation. When you have finished your investigation, you invite the person. You are ready to charge him to court. But you see, we try suspects on the pages of newspaper. We try suspects publicly. Like I read in the media this morning when I was going through the online newspapers. One Lagos Press has increased the amount to 10 billion naira. Lagos Press has increased it to 10 billion naira. But EFCC has not said so. And on the street now, they say, the money don't reach 10 billion. You just take somebody to the cleaners when you have not listened to the other side of it. This so-called holding charge is illegal. You don't rush to a magistrate court and get an order to reprimand somebody. And some lawyers have referred to Administrative Justice Act. That is not superior to it's an inferior law to the Constitution of Nigeria. So even to hold, I agree that the man is new. He wants to be seen to be working. The president will say, yes, he's working. Lamu, they did the same thing when he came. But for 4 years, he became deaf and dumb. Waziri did the same thing when she came. Let us give this one time for 6 months.
All right, thank you very much.
But it should not be so. Anybody, including Nwanyanwu, if you have seen him that he has used his fingers against the wealth, our common patrimony, do the right thing.
Must be asked to account.
But you must be asked to account. But don't do things that people will see you that you are targeting certain persons.
All right.
And that is exactly what is in the public domain now.
We definitely have time to talk more about this. Chief Dan Nwanyanwu, who is a former chairman, Board of Trustees, Labour Party. Thank you so much for your thoughts.
You're welcome.
Thank you so much for coming. Well, the program isn't over yet. It's time for us to bring you On Your Own by Muyiwa Afolabi.